So today we're going to take a few minutes of your time to talk about a competition law issue which can have a big impact on you and others in the TMT sector, information exchange. It's as relevant to small startups as it is to larger players. We hope to help you first to spot information exchange issues as they turn up in your day-to-day activities. Second, explain briefly what risks can arise. And most importantly, third, if you've identified any concerns, to give you our top tips on how to reduce the competition law risks. But before you can issue spot, perhaps it might be useful for us to explain exactly what we mean by information exchange. Sophie, perhaps you could expand on this.
Sure. The exchange of information is obviously crucial in this sector as it is in most other business sectors. All suppliers need to talk to one another in their day-to-day business in order to carry out that business. What we're talking about here is really information exchange which goes beyond what's necessary in normal day-to-day business and moves into something more problematic. At its most extreme, the information which is exchanged could relate to prices, which could in turn lead to price fixing. But I hope everyone watching already knows that that is a serious infringement of the competition rules. What we're really going to focus on today is information exchange which is problematic in an otherwise legitimate commercial context, so in an otherwise legitimate collaboration with third parties. But of course that might still seem very general, so Osman, perhaps you could put this into context for the TMT sector.
Sure. Let's run through some of the areas where information exchange issues have come up in the sector. As Sophie said, at the very extreme end of the spectrum are issues around bid rigging or collusive tendering. And this is where parties, usually direct competitors, collaborate to interfere with responses to competitive bids or tenders. This is pretty much akin to price fixing or market sharing, the very worst type of anti-competitive agreement. The UK competition authorities have certainly made it clear that any interference with public procurement processes will be looked at very closely. But as Sophie said, today we're focusing on the other occasions where you might have a legitimate reason to collaborate with others. For example, in joint tendering, exclusive partnering, or subcontracting, or indeed any form of collaboration with suppliers upstream to you, or indeed customers downstream to you, with actual competitors or with potential competitors. In many instances, information exchange can be pro-competitive, for example by allowing participation in a bid by those who otherwise would be unable to make a standalone bid. But just because there's a legitimate reason for entering into an information exchange with a third party doesn't mean to say that there can be a free flow of commercially sensitive information between independent players on the market. Maybe that's a good point to move on to our second issue, and that's to think a little bit about the competition law risks. So, Sophie, what exactly is wrong with information exchange?
Well, the aim of competition law is essentially to ensure that all players in a market are on a level playing field. The idea is that fair competition should be preserved. So that means, for example, not knowing in advance how others are going to react or act on the market, and preserving the freedom to act and react independently oneself. It also means making sure that all players on the market have access to the same levels of sort of public information. Any collusion between companies which gives those companies an unfair competitive advantage is likely to be an infringement. And if the collusion leads to players being actually shut out of the market, that's going to be particularly problematic. Competition lawyers who have a bit of a tendency to like jargon talk about foreclosure in this context, which may be shutting out competitors, suppliers or customers. And both of these concerns, collusion and foreclosure, can sometimes lead to competition law liability for your company. You probably already know, you see it in the headlines, that can involve very, very significant fines being levied, and it can also mean potentially subsequent damages actions. In the worst cases, there can even be personal liability for those who've been involved. There's a new criminal law regime, for example, being introduced in the UK at the moment.
If I could give just one example of information sharing sanctioned by the authorities, I'd refer to the fine on T-Mobile and other mobile operators a few years ago. In that instance, the companies met only once, and they didn't actually reach a formal agreement. They simply exchanged views on future behaviour on the market. This was enough to constitute an illegal information exchange. I would add that anything which gives the appearance of an illegal information exchange can be problematic in itself. Getting embroiled in a competition authority investigation is pretty undesirable. Such investigations can be hugely disruptive and at the very least can have a significant impact on your reputation. And that's even if it turns out that no illegal exchange took place. So that brings us to the most important third part of the webinar. Sophie, how should you go about assessing risk and how can you reduce competitional risk?
Well, the first thing to bear in mind is that information exchange is more likely to give rise to problems in certain kinds of markets. So it's worth thinking about the markets you're active in. Markets which have particularly fertile ground for information exchange problems are typically characterised by a high degree of transparency, so making it easier for partners to reach a common understanding and monitor that understanding. A small number of players or a very high concentration of players with big market shares, for example, which means that any information exchange is likely to have a significant impact. A level of stability in the market, quite often with standardised or homogeneous products, which means it is easier to exchange information and have an impact through that exchange. So conversely, if you're in a highly competitive or secretive market with complex differentiated products, you're probably less likely to run into information exchange issues of the type we're discussing today. The second thing you should think about is who you're collaborating with. Exchanging information with your direct competitors is always likely to be the most problematic. There's always a risk that you'll go just that little bit further than you really ought to. And because of this, it probably won't surprise you to know that a lot of information exchange issues have come up in the context of trade associations where direct competitors get together. However, even if you are dealing with parties upstream or downstream, issues can and do still arise. In particular, it's worth thinking about where the information is coming from and where it might go to. If you're exchanging strategic information with someone or they're exchanging strategic information with you, you have to think about the fact that they might be doing the same thing with other players on the market, potentially your direct competitors. There have been a succession of cases, so-called hub and spoke cases, where, for example, one upstream supplier has exchanged information with a number of downstream customers, or where one downstream distributor has been talking to a number of different suppliers. And in those instances, there have been infringements found because there's been a flow of information between all of between the single hub and all of the other players.
And that brings me on to the third broader point, and that's to think a little bit about the type of information that you're exchanging. Information of strategic value, particularly on price, is the most sensitive. But as mentioned, data relating to capacity and/or costs can also be sensitive. On the other hand, if information relates to logistics, personnel, or timetables, that's probably entirely legitimate and indeed necessary in commercial collaborations. Granular or individualized data is the most likely to give rise to concern. Aggregated or anonymized data is less likely to do so. Information on current or future plans is the most sensitive. Exchanging historic information generally isn't problematic, but there's no real cut-off point for when information is considered historic for competitional purposes. I take 1 year to be a rule of thumb. If it's commercially useless by the time you're exchanging it, it's probably fine to do so. As already mentioned, even a one-off exchange can in principle be problematic. But that said, the more frequently information exchanged, the more likely it is to be problematic. Collaborations which require ongoing, regular exchanges of data should certainly be carefully considered. And the final, and perhaps the most important thing to bear in mind, is that you should always limit any exchange of information to that which is strictly necessary for the purpose of the collaboration. So let's say that you're entering into a joint tender or a joint venture. Have a think about why the other party needs access to that information. Is it to help with the collaboration? Or is it just a nice to have, which might put you both in a better position with regard to others in the market? The cardinal rule is always limit the exchange to what is strictly necessary. So to conclude, perhaps we can try and distill some of what we've said into our top practical tips. Sophie?
So our number one tip is don't exchange information relating to pricing. That's probably, we hope we've made that clear to you throughout this session. And when we talk about pricing, that includes margins, discounts, and detailed cost levels. This is the most sensitive category of information, especially if it relates to present or future conduct. Even in the context of legitimate collaborations, only exchange this information relating to costs at an aggregated level. No one else needs to know the specifics. That's not something that needs to be shared. Generally, if the value in the exchange of information of whatever sort is primarily commercial, then that's a good sign that it's something that should be avoided. However, if it's primarily for the purpose of the collaboration that the exchange of information is needed, then that's likely then to be acceptable. Secondly, do limit the number of individuals who have access to any information which is exchanged. Often in joint tenders or collaborations, say, it's an easy way to reduce competition law risk significantly to put confidentiality rings or Chinese walls in place. When in that situation, you keep only those who really need to know on the inside, and everyone else is kept outside of the ring. It's particularly important in that sort of situation to do what you can to keep those who are very close to dealings in the market, so for example sales personnel, on the outside.
And I'd add to those, third, do document your collaborations properly. Set out the business rationale for the collaboration and the exchanges that it will entail. Keep minutes of meetings with competitors, document what was, and by implication what wasn't, discussed at the meeting. Be particularly careful around the margins of meetings. Collusion can equally well happen on the golf course or in a bar, as well as in a smoke-filled meeting room. Fourth, do follow up by any attempt by another company to involve you in the exchange of commercially sensitive information by stating that you do not wish to be involved. Keep a careful written record of any attempt to distance yourself from any problematic exchange. And that's pretty much all we had to say.
Yes, so remember, do try and make your business decisions independently. Of course, if you are collaborating with someone, you may need to exchange certain information and make certain decisions together. But as a general rule, remember that although you can anticipate and react intelligently to the market, you shouldn't be exchanging information that reduces the uncertainty which is crucial to competition. We hope that you found this to be useful, and of course, if you do have any questions, we've put a few sources of information on the slides. I've been Sophie Lawrance.
And I've been Osman Zafar. Please don't hesitate to get in touch with us if you have any questions. And remember, just because the way you do things is the way that they've always been done, doesn't mean that they're not problematic from a competition law perspective. Thank you for watching.